For this week's important development in bankruptcy, we are again at the U.S. Supreme Court because on Monday, the justices agreed to hear a second bankruptcy case in the term that will begin this coming October. This is an important case not only for bankruptcy, but for all of federal practice. The issue revolves around Section 363M of the Bankruptcy Code, on which there is a big 6-2 circuit split. The Section 363M tells us this. It says that on appeal, the reversal or modification of an order approving a sale or lease cannot affect the validity of the sale or lease unless there was a stay pending appeal. The Second Circuit several times has said that that section 363M is jurisdictional. And further, the Second Circuit said, because we lack appellate jurisdiction, we cannot review any aspect of the order approving a sale. Take this example. Let's assume that a bankruptcy court says that it is approving a sale of property, but party X gets none of the proceeds. The Second Circuit would say, I guess, that we have no appellate jurisdiction, and we therefore cannot even reach the question of whether party X was entitled to some of the proceeds. I dare to say that the other 6 circuits in the same situation would say, yes, we're not setting aside the sale, but we can review whether or not party X was entitled to some of the proceeds. This case, I'm guessing, will be argued sometime between October and December, unless there is an inordinate delay in the filing of the briefs. That means that we will get a decision from the justices, I would guess sometime between late January into March or early April. Now I'm going to get out on a limb and I'm going to make a guess that the Supreme Court sides with the majority of circuits and says that a provision like 363M is not jurisdictional. You can grant some relief on appeal, you just can't set aside the order approving the sale or the modification. And as I said, this is important throughout throughout federal practice, because there are dozens, perhaps hundreds of federal statutes that limit the relief that an appellate court can give on appeal. And if it's jurisdictional in all of those circumstances, then federal appellate courts have been ousted of a huge slice of what we think their appellate jurisdiction is. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something important about bankruptcy. Until then, be well, stay safe, good day.